Myself is Keerthiga, Assistant Professor, Department of Commerce, SF, Fatima College. Today's class we are going to discuss about the company law. In company law there are many aspects has been covered, but we are going to see the one of the main aspects in the company law. In content we are going to see about the meaning of company law, features, formation, commencement and directors. What are the various type of directors has been in the company law, and the ultimate is a final is a winding up procedure. First and foremost, what is meant by company? So the company cannot act on his own name. Being an artificial person, it is mainly created only by the law. So the law cannot be changed at all. Even if it is an old act or a new act, the law should not be changed. So all the company, they have to follow the act. So if it is a 1915 section 13 subsection 1, the Companies Act has been defined as if the company has formed and registered under any one of the act or an existing company. So if any company has been registered under any one of the act, means we can say it is a company. They have to follow the rules and regulation which has been given in the act. Next one is the features of a company. There are some many features has been covered. Some of the main features are the company. First one is separate legal entity. So being on separate legal entity, always the companies always differ from the members. The members are always distinct, different from the company. Second one is limited liabilities. So invariably many of the companies are limited liability. They are holding the liability only up to the value of the nominal value or the registered share value. Transferability of shares. So the transferability of shares, in case of a public company, we can easily transfer the company shares. But in case of a private company, the shares transferability will be restricted. So only when the articles or the company rules has been followed, we can transfer the shares easily. Next one is a perpetual succession. The perpetual succession is nothing but the company will withstand forever. Even an old employees or new employee does not affect the companies. In case, for example, in case of retirement, in case of a death of the person, will not affect the companies. So the company will run forever. Next one is can own and sell the properties. So the company main as features is the company should sell the company's property only on his own name, not on the other's name. Like they should not sell the company's property in the name of the director or the shareholders or the secretary. The last one is can sue and be sued. So being on company a legal entity, he can act by themselves. So the company can file a case against the members or the creditors who's making faults against on company. So the members also, they have a right to file a case against the company. That's why we can say can sue and be sued. Next one is formation. In formation, the main role played by is a promoter. The promoter will do all the activities which are related to the formation of the company. So during the incorporation, when the company want to start, we can say it is an incorporation of the company. He will do all the preliminary works committed in the company. He is a promoter. So the promoter will prepare the MOA, that is a memorandum of association. Next one is AOA, that is an articles of association. So mainly these two documents should be prepared by the promoter only during the incorporation period. So in incorporation period, that the promoter they will appoint a managing director as well as the manager for the company. So the promoter will see the what are the qualification has been possessed by the director, manager, secretary, and how much amount of shares they should be held by them. Next one is effects of incorporation. Only after the incorporation only the companies can able to commence their business. Without an incorporation, no one company cannot start their business. The next one is a commencement. The main in incorporation, commencement. For private company, the commencement of a business need not be required. So the link, once the company wants to start it, after the incorporation, the company will issue a prospectus to the public. They will be asking the minimum, what is the minimum subscription should be held by them. Directors' shares also be limited. Next one is a directors. So after the incorporation, the main role took place is a director's role and types, appointment and their powers. The role of a director will be acted, they will be called as a board of director. For a large scale business, for a large scale company, the board of director, the maximum the company they can held 15 as a director. Role of a director. The director always have some fiduciary relationship with the company. It's nothing but they should have a trust and faith on the companies. They should act only on the interest of the companies, not for the personal. Next one is types of directors. There are many types of directors like managing director, whole-time director, part-time director, independent director, nominee director, additional director, and then alternative directors. So the appointment of directors will be fixed only on the basis of which has been mentioned in the articles of association, and it should be decided by all the shareholders. So during any annual general meeting or any statutory meeting, the appointment of director will be done. Thank you so much for watching this video.